Hello everyone. Today I'm going to discuss about one of the important factors that why should international lawyers care about US IP law? Because the country, the more they have different kind of innovation and invention, they can contribute more. Four type of IP we have: trade secret, patent, copyright, trademarks. When is there a valid IP right? When it is it infringed? Are there any limitation or defense? What is remedy? So validity, infringement, limitations, and remedies. Validity, trade secrets. Secrets, value due to secrecy, reasonable effort. Patent, noble, non-obvious, useful, adequate, disclosed. No abstract idea or law of natures. Copyright, independent creations, modicium of creativity, fixation, no idea, fact, or useful articles. Trademarks, source identifying, inherent, acquire, disinfectiveness, priority of use, no generic word or functional features. Infringement, acquisition by improper means or violations of confidential relationship. All elements rule making using offensive to sell, selling importance, acquire copying or substantial similarities. Beside that, we have to know that these things actually likelihood of confusion or deletion due to defendant use as a mark in commerce. Limitation, independent discovery, reverse engineering, experimental use, inequitable conduct, fast sales, fair use, independent creation, fast sales, abundant descriptions or nominative fair use, fast sales. Remedies, eBay provide framework for evaluations whether injunction is appropriate, damage also available, potential criminal liability in all but patent. Source of US IP law: Federal Patent Act and Copyright Act. Trademarks, Federal Lanham Acts and State Law of Unfair Competition. Trade Secret, State Status, New Federal Defense Trade Secret. US IP law institution: Congress and state legislations, US Supreme Court, state Supreme Court, law state courts, 13 US Court of Appeal, US Patent and Trademark Office, 94 US District Court, Copyright Office, Food and Drug Administrations. Trade secret law: definitely it might need to be secret. When do you have a trade secret? Uniform Trade Secret Act. Trade secret means information that drive independent economic value from not being generally known to and not being readily ascertainable by proper means by other person, and is the subject of effort that are reasonable under the circumstance to maintain its secrecy. When as a trade secret misappears, thief, improper means, violation of a confidential relationship. What are the limitation of trade secret? Independent discovery, reverse engineering. So if we go for the validity, in fragments, limitation, and remedies, what we find from trade secret. Secret scarcity, value due to scarcity and reasonable effort. Novel, non-virus, useful, adequate, disclose or obstacle idea or law of natures. Independent creation, medium of creation, fixation, no item, fact or useful article, source identification, inherent, acquired, disinfections. Acquisition by improper means or violation of confident relationship, all element rule making using offering to sell, selling, import. Actual copying or substantial similarity. Likelihood of confusion or dilution due to defendant use as a mark in commerce. Patent law. For the patent law, this is a very good source that we can develop and we can manage and we can control our law. What is patent law? Patent Act confident at 35 USC. Federal court have exclusive jurisdictions and federal circuit has exclusive appellate jurisdictions. Many recent changes in part due to concern about patent troll and litigation abuse. 22 Supreme Court patent case since 2010. 2011's American Invest Act, including expanded post-grant prosecution before PTO. State law targeting bad faith patent assertions. Attorney of a patent claim. Pemble transition body elements, a drive from writing, a wooden cycle with a hollow course, said hollow course continuing material comprising 90%, easier material attached to one end or said wooden cinders. So when it is patent valid, 101 is a patent subject matter, then its utility, enable and written descriptions, claim, definiteness, novelty, non-obvious business. Patent subject matters. Border statutory language, but Supreme Court important impact expectation for nature and abstract idea. For recent case huge impact in 2 years after June 2014, 2001 invalidation out of 2087 decisions 101 can be so what is utility can be important for chemicals and biotech invention do not need human clinical trial but need some specific utility but usually satisfied silly or immoral invention still have utility. Adequate disclosure, does the disclosure enable the person having ordered skill in the art to make and use the inventions? Written description, in the description adequate to allow the posita to recognize that the inventors possess what is claims. Claim definitions. Supreme Court revised test in novellas and biologists. Patent is invalid for ident- indefiniteness of claim fail to inform with reasonable certainty those skilled in the art about the scope of the inventions. Novelty and statutory bars. Prior art the disclosure every element of the claim in invention destroy novelty. Unlike in Europe, invention who publish has 1 year grace period to file patents. America Invent Act shift from first to invent to the first to file system. The ultimate conditions of patentability test would the difference between the prior art and the claim invention have been obvious to a posita. US court often look for objective evidence, secondary considerations such as failure of other and commercial success. There are more interesting information like when is a patent infringement, literature infringement, making using of offering to sell, selling and importing of patent inventions, doctrine of equivalence, infringement products are placed as equivalent to every elements of patent invention, active inducence, contributory infringement, supplying from the US components of a patent invention for use abroad, important into the USA product made abroad by a patent process. What are the limitations? Patent unenforceable for inadequate conduct, including contradicting statement made to other patent office, very narrow experimental use exception, exhaustion of the right by fast sales. Utility patent protect functional aspect of inventions are valid for 20 years from fillings. Desire patent protect ornamentals design and are valid for 14 days. So there is also some important aspect of validity, infringement, limitation, and remedies. And validity is for there is a secret value due to secrecy, reasonable effort. Infringement, acquisition by improper means or violations of confidential relationship. So what is the limitation? Independent disclosure, reverse engineering, and remedy is eBay provide framework for evaluating whether injunction is appropriate. So there is a copyright law. We have to follow this copyright law and it actually help us a lot. When do you have a valid copyright? Original work of authorships, independent creations plus modifying of creativity, fixed in any tangible medium of expression, more than transitory durations, no copyright on fact, ideas or useful articles is important. So what cannot you protect? Law of nature, abstract ideas, obvious combinations of existing elements, no non-useful article. Copyright fact, idea, uncertain computations of the existing material, useful article. When is copyright infringement? Direct liability, reproduction right, right to prepare derivative works, right to distribute, right to perform, limit protections for moral right under Visual Artists' Right Act. Indirect liability based on tradition tort principles and patent standard for inducements or contributory infringement. What are the limitations? Many specific stationery exemption, liberatory right, classroom use, stationery license. Most important is fair use. Fair use, parodies, recording TV, thumbnails, images, third trust, Google Books. Not fair use, exception the art of a book pre-publication, photocopying articles for industry research, unauthorized or non-paradox sequences. For this particular issue, there is a validity, there is the infringements, there is the limitations and remedies. So trademark law, name of this brand and the name of these plants, this is called the trademark law. Why protect trademark? Different from trade secret, patent, copyright do not need to be incentivize creations of new marks. Case or outcome can develop on what theory could find most compelling, reducing consumer search costs, provide incentive for a farm to invest in quality, protecting farm properly right. When to have a valid trademarks? Genetics functional features, descriptive visual centers, suggestive cooperations, arbitrary appeal, fanciful codecs, functional feature never protectables, color design protectable only with acquiring disinfections, and inherent distinctive or source of identification. Any source identification symbols, including color or trade dress, that meets the threshold of distinctiveness. No proper for formal features. Priority goes to the first use in commerce. When is a trademark infringed? Defendant must be using as a mark in commerce. Likelihood of the confusion. Multi-factor test varies by circuits. Type of conclusion: product confusion, source confusions, confusion as to sponsorship, initial interest confusion, post-sale confusion, reverse confusion. Delusions: playful own famous mark. Association between plain false and the defendant's mark is likely to cause their blunder and tarnishments. Dilutions by blue rings. There is a Rolls-Royce, and Rolls-Royce, different brand we can use. On the other hand, dilutions by the tarnishments harms the reputations of the famous marks like Enjoy Coca-Cola. There are different brand we can use, go for illusions. No likelihood of confusion or delusions. Successful parody dependent of firmness of LB marks and copying enough to involve. What are the limitations? Fair use, abundance, descriptive, nominative, descriptive TM owner products, descriptive other products. These are the different kind of things, and definitely we have validity, infringements, limitation, and remedies. And from there we can find source identification, inherent or acquired distinctive priority of use, no generic word or functional features, likelihood of confusion or dilution due to the defender use as a mark as commerce, abundant descriptions or nominations, fair use, fast sales. So there are different kind of descriptive models and other things which is actually help us to grow our sustainabilities. So for that particular issue, I strongly believe that we need to grow some sort of economical aspects. We need to grow some sort of a different kind of issues which is help us to grow our copyright and patent issues in an effective way. So as we are moving with this copyright and patent issue, there are many interesting factors we can learn, and especially different kind of developing nations, if they can move and learn different kind of copyright and patent issues, it will help them. So what kind of chain activities it has: creation, innovations, commercialization, protections, enforcements. So if we go that it is a intellectual property, so intellectual property has copyright, industrial property, trademarks, patent, industry design, confidential information, geographical identifications. Beside that, we can go for tangible property, land, house, state car, intangible property, intellectual property, intangible wealth, easy, appropriate, and reproduced. Once created, the marginal cost of reproduction is uh, uh, negligible. Beside that, we can discuss about economic right of creator, commercial explanation of owner of IP, explain expenditure, transformation of technology, and cultural developments. And research and development is very much important. Why IP protection is given? Capital expenditure, also new product, marketing and advertisement, no free leaders, maintaining loyal followers, and profit. IP as a property can be sold, can be bought, can be leased, can be under a will, or can be assigned. Beside that, the IP is a legal custodian, three machinery of administration, IP office, the external machines, the courts. The Paris Convert for Protection for Industrial Property, 1976, Barnier Conventions for the Protection of Literature and Artist Work, 1971, Trade-Related Aspect of Intellectual Property Agreement, 1994, WCT, PCT, 2004. Now, beside that, protection for industrial property, trademark, patent, unfair competition, governed by domestic legislations, protection by literary and artistic work, governed by the national legislations, digital agenda, technological measures such as circumventions of technological measures, addition to Paris and Berne, minimum equivalent, most favored national treatment, strong enforcement procedures, as well as making it easier to make patent applicable, designative country and international face to face is very important. So if we go the basic principle for the international convention, we can find laying down the minimum requirement for the international legislations. Member may be shall not be obtained to implement more intensive protections in their law than it is requested by the agreement. Each member shall accord the nations of other member treatment no less favor than its accord to its own national. So USA, India is a very good example. USA versus India, not open to individuals. And beside that, there are some specific law: Copyright Act 1987, Trademark Act 1976, Patent Act 1983, Industrial Design Act 1996, Geographical Indicate Act 2000, Law of Tort, Passion of Confidential Informations. These are very important. The protection given by law for a term of years to the consumer, author, etc. to make copies to their work. Work include literary, artistics, musical, film, sound recording, broadcast, commercial and moral rights, no registration provisions. So for protection for the trademarks, we have commercial explanation of a product. To identify the product, given it a name. Mark includes a device, brand, healing, label, tickers, name, signature, word, letter, numerals, or any other combination. Does not include on sound or smells. So and we can follow some of the trademark, like can either be registered or not registered. Advance of registered trademarks, we can go for application, can be made for goods and service, and perform certain function such as identification of quality, identification a trade connections is very important. Choosing the correct mark. Compare the trademark dove to using the mark cross. Would the frog restaurants be acceptable? Would marksman and weekend sex to be acceptable? We can go for the basic idea of granting a patents, the application appointed of the government for the right of patent, and in returns for the monopoly give he must disclose everything about the inventions in the patent documents, and it will be duration 20 years. Patent for inventions, patent can be applied for a product or a process. Patentable invention must be new, involve an inventive step and industry applicable, priority date fast to flies. And beside that, we can go for innovation, anticipating the change that is coming. Kodak, Polaroid, hairs, many of the interesting things actually happening around the world. So for this the lawyer, the business organizations, and everyone, they have to understand this patent. They have to understand the copyright issue. They have to understand that how they can implement and manage their business. If they can implement and manage their business in an effective way, that time they have proper control and they can go for the global market. So if you have any kind of question, you can communicate with me, and definitely we will give you different kind of question answers. Thank you everyone for joining today's session.